In January of 2025, legislation was enacted that was meant to deliver justice to 3.2 million Americans. Coverage of it was everywhere. A long-standing wrong from decades back finally addressed, payments being mailed, funds returned, and for the majority of those individuals, the system delivered. The Social Security Administration distributed over 3.1 million payments, adding up to $17 billion, and countless retirees opened their accounts to find a deposit they had been waiting 4 decades to see. But here is what the news cycle stopped reporting on, and that is precisely why I am recording this video. When an agency rushes through 3.2 million adjustments, it does not wrap up every single one neatly. Certain individuals received their money, certain individuals received only part of it, certain individuals got their lump sum payment, yet are even now in 2026 receiving a monthly figure still based on the old flawed calculation. And one particular group, the one that concerns me most, was never recorded in the system to be corrected at all, meaning no automatic deposit was ever scheduled for them, regardless of how patiently they sit and wait. I am Franklin, and I work as an elder law attorney. I am not going to use this video to walk through the backstory of 2 regulations you have most likely already heard plenty about. Those regulations are history. That chapter is closed. What I will do instead is reveal the gap to you, the territory between the official narrative claiming this matter is wrapped up and the actual situation where a significant number of people are still owed funds they have yet to see. Because if you happen to fall into that gap, the most dangerous thing you can do is trust the headlines and presume your funds are coming. For certain viewers, nothing is coming unless you go retrieve it yourself. Here is what is on the line in actual dollars. The typical retroactive payment that was distributed came to roughly $6,710. The typical ongoing monthly raise was approximately $360, which adds up to more than $4,300 each year for the remainder of your retirement years. But for the individuals hit the hardest, the widows and widowers whose complete survivor benefit had been zeroed out, the figures climbed dramatically higher. A survivor benefit that was completely eliminated can translate into a retroactive payment exceeding $22,000, along with that entire benefit restored every month moving forward. That is the $22,080 referenced in the title, and it is genuine. And for certain individuals, it is still sitting there unclaimed. So today I am going to walk you through the 3 categories of people the cleanup overlooked, how you can determine in roughly 10 minutes whether you belong to one of them, and the precise steps to retrieve your money from the queue. And I am holding back the most critical group for the end, the one in which the money does not arrive automatically under any circumstances, because that is the group with the highest risk of forfeiting everything by trusting that the system has them covered. A quick note on logistics. This video serves educational purposes only and does not constitute legal or financial counsel. Always verify your individual circumstances directly with the Social Security Administration. If you have not subscribed yet, please do so now and hit the notification bell, since this channel was built specifically to expose these kinds of gaps before they end up costing you. Now, let me reveal who got overlooked. Before I expose the gap, you need to understand in straightforward terms whether this legislation affects you in any way, because if it does not, none of what follows holds any weight. And if it does, everything I share next concerns your money. So let me make this quick and tangible. There are 4 categories of people this covers, and I want you to listen carefully for yourself. The unifying element across all 4 is one particular circumstance. At some stage, either you or your spouse held a position that contributed to its own pension fund rather than contributing to Social Security taxes, a government job that opted out of participating in the Social Security framework. If that aligns with your career history or that of your deceased husband or wife, stay tuned carefully, because one or possibly both of the former rules almost definitely affected your benefit. Category 1, you spent time working as a public school educator, and at some stage during your lifetime, you also worked in other positions where Social Security taxes were being deducted from your earnings. This pattern was particularly widespread across a group of states where educators were excluded from Social Security participation. States such as California, Texas, Illinois, Ohio, Massachusetts, Colorado, Connecticut, Louisiana, Kentucky, Maine, Missouri, Nevada, Rhode Island, Georgia, and Alaska. If you taught within any of those states and additionally contributed to Social Security via different employment, this describes you. Category 2. You spent your career as a firefighter, a police officer, or any kind of state or local government worker within that same variety of non-covered framework, and you additionally contributed to Social Security at another stage during your working life. Identical mechanism, identical impact on your benefit. Category 3, you work for the federal government, but more precisely, someone brought aboard before January 1st, 1984, under the former Civil Service Retirement Program referred to as CSRS, not the more recent FERS program, CSRS. This difference carries tremendous weight, and if you honestly are uncertain which program you fell under, that detail can be verified by reviewing your former federal benefits documents or reaching out to your old agency's HR division. The two programs were handled entirely differently. Category 4, and this is the one I want you to focus on the closest, you are a widow or widower whose spousal or survivor benefit was diminished or wiped out entirely because you collect your own government pension. If you ever attempted to claim a benefit through your deceased spouse's earnings record and were informed that you would receive almost nothing or absolutely nothing due to your own pension, you fall directly into this category, and you are the individual for whom this video carries the greatest significance. If you find yourself in any of those 4 categories, this legislation pertains to you directly, and there is an actual chance that money is owed to you which still has not landed in your account. And here is the essential reframing for 2026 in particular. 12 months ago, the proper guidance was hold tight, your fix is likely on its way. That guidance is no longer valid. We are now sufficiently far beyond the passage of this law that if your funds have yet to land, holding tight is no longer the solution. The automatic rollout has mostly concluded. What remains is the mop-up. And the mop-up will not always locate you. So at this point, the question is not, is it on the way? The question is, did it arrive? And if not, what is the reason? That is what the next segment addresses. This is the core of this video, the portion the headlines missed. When the Social Security Administration worked through these millions of adjustments, the effort was not consistent. The agency itself disclosed that it had completed the vast majority of files, but it transparently acknowledged that some portion was still outstanding, particularly the intricate ones, those with tangled benefit histories that the automated programs could not resolve neatly. The agency's own internal watchdog identified the backlog as a legitimate worry. So the official narrative, the one suggesting this is largely wrapped up, holds true for most individuals and quietly fails to apply to a sizable minority. And there are 3 different ways to land in that minority. Listen for which one might describe you. The first category of person left in the dust is the never corrected. This is somebody whose monthly benefit currently in 2026 continues to be computed under the former diminished calculation. The fix simply was never implemented on their record or became trapped in a processing queue and never resurfaced. They continue receiving the same shrunken check they have always received with no letter, no warning, no clarification, because the agency will not send you a notification announcing, "We have not reached you yet." From the surface, nothing appears off. The payment shows up on schedule. It merely shows up wrong every month the same way it has for ages. The only path this individual discovers it is by proactively investigating, since the silence feels indistinguishable from things being perfectly fine. The second category of person left in the dust is the partially corrected, and this category is tricky. This describes somebody who received the one-time retroactive lump sum, the deposit that landed in their account, and reasonably presumed the entire matter was resolved. The funds arrived, so it must be done, correct? Not always. In certain instances, the retroactive sum was paid, yet the ongoing monthly benefit was never updated to reflect the corrected figure. So they got their retroactive deposit, felt a wave of relief, and resumed collecting a monthly benefit still operating under the former diminished calculation. They are losing money each and every month and remain unaware precisely because the lump sum persuaded them that everything had been wrapped up. The lump sum was authentic. The monthly adjustment was never completed. Both realities can coexist simultaneously, and there exists a third version within this category worth identifying. The individual who was eligible for a fix under both former rules but only had one of them implemented. Their file was partly cleaned up. One deduction was reversed. The other stayed in effect. Once again, money continues to disappear. Once again, no letter informing them. The third category of person left in the dust is the gravest of all, and I am dedicating an entire section to them shortly because the remedy is entirely different. But allow me to identify them here so you grasp the complete landscape. These are the widows and widowers whose survivor benefit was not simply reduced under the former rules, but eliminated completely, reduced to nothing. And here is the snare that makes their predicament so distinctive. When a benefit was reduced to 0 years back, plenty of these widows never went through with formally applying, or their application was outright rejected at that time. Which means that today, there is no approved claim resting in the system for the agency to revisit and adjust. You cannot automatically reinstate a benefit that was never granted to begin with. The system has nothing to switch back on. For this group, the funds are not stuck somewhere in a queue. They are not arriving whatsoever because there is no claim for them to be tied to. That represents an entirely different problem and demands an entirely different response, which is exactly the reason I am tackling it on its own. So those are the three: the never corrected, still on the former calculation; the partially corrected, lump sum received yet monthly amount remains incorrect; and the never applied widow lacking any claim the system can repair. The query now is simple. Which one, if applicable, describes you? Here is the method to discover it. You should not have to guess which category you belong to. You can establish it with near certainty in roughly 10 minutes, and you really ought to do this within the week. Here is exactly the procedure in 2 steps before we get to the special widow scenario. The first step is to access your account through the website. Head to ssa.gov and sign into your My Social Security account. If you have not already established one, set it up. You will require your Social Security number along with a valid email address, and the entire registration takes roughly 10 minutes. This account ranks as the single most valuable resource at your disposal because it reveals what the agency is genuinely doing with your benefit, rather than what a headline claims they did for everybody. After you are signed in, navigate to your benefit statement and examine 2 particular items. First, your current monthly benefit figure. Second, search for any line or notation mentioning the former rules, the windfall provision, or the pension offset. Now, here is the giveaway, the indicator that exposes whether you are left in the dust. Pose one question to yourself. Has my monthly benefit truly increased since early 2025? If you were impacted by these rules and your monthly payment today matches what it was prior to the law going into effect, that is your warning sign. It indicates that your fix was most likely never finished. A properly adjusted benefit would display a larger monthly figure. If the number has not budged, your case is most likely lodged in the gap, either never handled or only partially handled. The second step is to verify it through a phone call because the online statement does not consistently reflect the full processing record. Reach the Social Security Administration directly by dialing 1-800-772-1213. When a representative comes on the line, do not pose a vague inquiry and cross your fingers that they figure it out. Use exact wording. State, I want to verify whether my account has been fully corrected under the Social Security Fairness Act. Jot that sentence down before you place the call so you deliver it cleanly. That precise wording signals to the representative exactly which system to access and which correction record to retrieve. They are able to inform you during that call whether your case has been closed, remains pending, or was never assigned to begin with. Then, depending on their answer, take the appropriate next action. If they inform you it is still pending, request the projected processing date and ask them to document on your record that you reached out to follow up, because a documented follow-up can carry weight. If they inform you it has been closed, but your monthly figure clearly never went up and you are certain you were affected, do not take that as the conclusive answer. State these precise words. I would like to file a formal request for reconsideration. That particular wording triggers an authentic examination of your entire correction file, not merely a brush-off and a vague promise to follow up. It compels a genuine re-examination. Those two steps, the online verification and the telephone confirmation, will inform almost anyone whether their funds have arrived or remain trapped. But for one group, even an immaculate phone call falls short because the issue is not that their correction is trapped. It is that there is nothing available to correct. That describes the widow scenario, and it comes next. Now, I want to address the widows and widowers directly because your circumstance differs from everyone else discussed in this video. And if there is just one thing you remember, make it this segment. For every other group, the funds exist somewhere within the system, and the task is to shake them free. For many among you, the funds are not within the system whatsoever, and no quantity of waiting or follow-up will generate them because nothing exists there to follow up about. Here is why your situation differs. Said simply, under the former pension offset rule, a survivor benefit was reduced by 2/3 of your government pension. For many widows, that arithmetic did not merely diminish the benefit, it eliminated it altogether. If your pension was sizable enough, 2/3 of it surpassed your entire survivor benefit. So the benefit was reduced completely down to zero. You were eligible for nothing from your deceased spouse's record. Decades of your husband or wife contributing to Social Security, and the rule delivered you a zero. And here is the consequence that creates the snare. When the benefit calculated out to zero, what did the majority of people in that circumstance do? They did not submit an application. Why would anyone fill out paperwork for a benefit the government had already informed them would amount to nothing? Many widows never turned in the documentation whatsoever. Others submitted it and saw it formally rejected. Regardless of the path, the outcome today is identical. There is no approved survivor claim resting in the Social Security system bearing your name. Now tie that to the way the correction operates. The agency's automated procedure scans through current approved claims and recomputes them, excluding the former deduction. That is the mechanism behind the millions of automatic disbursements. But you cannot recompute a claim that does not exist. If you never had an approved survivor benefit, there is nothing within the system for the automated procedure to locate, repair, and disburse. The correction engine glides right past you because from its perspective, you are not somebody whose benefit was diminished. You are somebody without any claim whatsoever. So as teachers and firefighters receive automatic deposits, the widow whose benefit was reduced to nothing receives zero. And to make matters worse, she frequently believes the law looked after her the same way it looked after everyone else. This stands as the single costliest misconception in this whole subject, because this is the group due the largest sum. A fully eliminated survivor benefit once reinstated can amount to a retroactive payment comfortably above $22,000, along with that whole monthly benefit restored for the remainder of her lifetime. And it is the group most prone to receiving exactly nothing because the remedy demands an action that almost no one realizes they need to take. Here is the action, and it represents the whole purpose of this segment. If your survivor benefit was wiped out completely, you very likely need to submit a brand new survivor benefit application, not a follow-up, not a reconsideration of an existing claim, an entirely new application, because there is no claim available to reconsider. When you contact Social Security, pose this precise question: does my case require a new survivor benefit application under the Social Security Fairness Act? Write it down and pose it word for word. That single question represents the difference between receiving more than $20,000 and watching it remain in a system that will never independently send it your way. So allow me to bring the entire picture into focus, because the takeaway here is not the law itself. The law accomplished what it set out to do for most individuals. The takeaway is the gap between resolved for most and resolved for you. The news told a tidy narrative. A wrong was made right. The payments went out. The matter is closed. And for the bulk of people, that holds true. But beneath that tidy narrative are three categories of people. The cleanup overlooked them. The never corrected, continuing to receive the former, diminished sum every month without any awareness. The partially corrected, who received the lump sum and presumed the rest fell into place when the monthly fix was never completed. And the widow whose benefit was reduced to nothing, who lacks any claim within the system and will receive nothing unless she submits a new one. Here is the common thread running through all three. In 2026, silence coming from Social Security does not signify that everything is fine. 12 months back it did. No communication suggested your fix was likely still en route. Now, the automatic rollout has largely concluded, and silence increasingly signifies that your case landed in the gap, and no one is coming to track you down. The funds do not accumulate interest while they wait. They do not move up the line by themselves. They remain right where they sit until you go verify whether they belong to you and whether they shifted. So here is your week ahead. Sign into your SSA.gov account and verify whether your monthly benefit actually increased since early 2025. Dial 1-800-772-1213 and recite the precise verification sentence to find out whether your case is closed, pending, or never assigned. If it is closed but obviously incorrect, request reconsideration using those exact words. And if you are a widow whose benefit was wiped out, pose the one question on which the whole outcome hinges. Does my case require a new survivor benefit application? 4 steps, 1 afternoon, potentially tens of thousands of dollars. Here is the single concept I want you to take away from this video. A law being enacted is not equivalent to a payment showing up. The Social Security Fairness Act resolved a 40-year injustice, and the system performed the work for most individuals automatically, but most is not everyone. And if you find yourself in the gap, the official narrative claiming this is wrapped up is the exact thing that will cost you, because it persuades you to wait around for funds that are not arriving on their own. So perform one task right now before closing out this video. Forward it to one person you care about who is past 60 and held a public sector job or whose deceased spouse held one, a retired educator, a former firefighter, a widow who was informed years back that she would collect nothing from her husband's earnings record. That single share could become the reason a $6,710 payment or a $22,000 one finally exits the system and lands in their account. This video serves educational purposes only and does not constitute legal or financial counsel. Always verify your particular circumstances directly with the Social Security Administration. The law repaired the rule. Only you can verify that it repaired your payment. Now go check.